I'm Justin Idiart. I've been here. I moved to the Rogue Valley in 2001, but I worked with my older brother Damien for about 10 years before I decided, okay, I'll go ahead and be a lawyer. So I've been practicing since 2011. And we try to focus just on civil cases, a lot of the tort cases, which is an injury, right? So I've had my experience in that. I try to stay away from family law, try to stay away from criminal, and I try to tell people, a lawyer's kind of like a doctor. You're not going to go to a back surgeon to fix your foot. And a lot of people think lawyers are just going to solve all problems or understand the law and everything. You're actually worse off going to someone that doesn't know what they're talking about in criminal. So I try to stay away from that, try to guide people as best I can. So we have a firm where there's 7 lawyers in our firm here, and we have a lot of support people. So we have about 50 people total. And we kind of have a higher volume of cases. So I don't know if it's good or not, but I have a lot of civil attorneys. So today I had like 2 phone calls from defense attorneys, and they'll call me and they'll say, will you take this case? Because they're difficult cases, difficult clients that have usually fired their other attorney. And they'll say, will you please jump on and take this? Now, I don't know if that's a compliment because I'm a good lawyer, because I can help them, navigate, help difficult clients. Or maybe I'm a bad lawyer, they know I'll just push over Justin and we can get a deal done. But I think at the end of the day, whether we're on plaintiff side or defense side, and here in the court, you're looking for a resolution of the case. Nobody wants to fight forever. And so you want to get this case resolved. So I think that's always the goal. You're in a civil case, we're not in the criminal system. Civil case, usually we're fighting about money to try to make people whole the best we can. So sometimes you're going to end up in a situation where, do I have a small claims case or do I have a civil case? And I think there's just a few criteria. I'm glad to have you all here and Melanie here to kind of help navigate, when you know what to do. So a small claims, from my understanding, small claims has to be $10,000 or less. In civil court, you can file for $750 and up to millions of dollars. I filed my first $1 billion lawsuit in Multnomah for the people that were in the Alaska Airlines thing where the door blew out and they thought they were going to die. Because I tried to file without an amount. And they said, you have to have an amount. So I said, okay, we'll go for $1 billion. But we're not going to end up there. But you have to have some kind of amount, right? Because the court and the other party that you're suing has to have some idea, what are we talking about here? How much do you want? So usually, if you're $10,000 or less, it's going to be hard to get a lawyer. And we'll talk about that. But you're in small claims court if you're suing individuals or sole proprietors of a business. So if they haven't incorporated their business or created an LLC, they could go in and represent themselves. They can represent their business. If they're an actual business like a corporation or LLC, that person can't go in and represent the business. They have to hire a lawyer. So a lot of people don't know that. They think, it's an LLC, it's really just me. No, you actually need a lawyer to represent the LLC. And so you can't be an LLC in small claims. You can sue one. As a plaintiff, you can sue a defendant, but they're probably going to, if they're a reputable LLC or they have some money, they're going to kick it out. And so you're going to end up needing a lawyer anyway. So I'd say if you're thinking about suing a business, you might end up just in civil case anyway. So think about that from the beginning. And you're going to save yourself some time. In small claims court, there are no lawyers. So that could be good, maybe for the litigants, but usually for the judge, it's not so fun because the judge is not there to advise people. He's there to really try to call, or she is trying to do balls and strikes. But often when you have pro se litigants, they don't know the rules. So the judge is trying to not show more bias to one side or the other, but they're trying to help them along to get a resolution to this. So if you're in civil cases, really you should have lawyers. If you're not represented, lots of times I know family law, there's not enough lawyers. Other areas of law, there's landlord-tenant, not enough lawyers. Civil, usually if you have a decent case, you're going to be able to find a lawyer if it's worth some money, the $10,000 or more. And bench trial, in small claims, you're going to end up with a bench trial. The judge is going to hear the evidence and come out with a decision. That can always be appealed into regular civil court. In civil court, you can still choose a bench trial if you want, or you're entitled to a jury trial, 6 people, 12 people. So these are kind of some of the parameters that we see. Now, is it worth hiring a lawyer? It's going to depend on your claim amount, right? On the kind of the complexity of your case. Family law, landlord-tenant, that's dealing with your family, your place of living. Those are important cases, even if it's not about big money. It's important to get lawyers involved if you can. On the civil side, you have 2 kinds of law, right? You basically have your injuries or your contracts. If you're on an injury case, usually you're going to hire a lawyer under a contingent fee, which is what I do. So I'm not going to get paid unless I win. I don't want to get, and my client's not going to get any money unless we win. But if I'm going to take the case, it has to be enough to make it worth my time, right? So you're looking at kind of more significant cases. Now, we have a bigger firm. We try to take more cases, more clients to try to help more people. But most injury firms are going to cherry pick. They're just going to take higher value cases or cases without liability problems. So lots of times these people are trying to find lawyers, especially in medical malpractice. Very difficult, very expensive, takes a lot of time. So it's hard to find lawyers. On the contract side, you're going to have to end up paying lawyers probably their hourly rate. It's probably about $400 an hour. They're going to want 10 hours up front, so you got to come up with $4,000, and that's just the beginning. So sometimes those are the things that pro se litigants are having to face. Why can't I get a lawyer? Why do I have to do this on my own? That's why coming to the Resource Center here in Jackson County Court is a wonderful resource. They can help guide you through these things with civil, whether you're going to do a small claims or a civil case. Before I jump into the resources, do you guys have any questions about kind of this scenario?
And I was just wondering if you could remind people that attorneys are not appointed for these types of matters.
Yes, good point. It's like, I'm entitled to an attorney, or I got sued. I should have an attorney. Only if it's in criminal, right? That's the only place the Constitution gives you right to an attorney. Good point.
And the subjects that we can assist with in the Resource Center are that we can direct them to the small claims packets. We can review and read instructions, and we can refer them to the civil pleadings books and rules.
Great. Can't give legal advice. I can't fill out forms for you.
We don't have complaints.
You have to look up other, and I'll share with you, you have in my packet here, some other complaints that I've done, 4 different kinds of cases. But all those are public record. Usually, on one of these, I saw another attorney just copied what I did. Just changed out the names, copied it, filed it himself. And it's the exact same thing. Again, maybe that's good. Maybe I'm a good lawyer. Maybe that's a bad lawyer, just lazy. I don't know, right? But it's unfortunate when you go through law school, and Ray can attest to this. In law school, in regular school, it's all about, everybody has to do their own work. You can't plagiarize. You can't copy. You get out of law school, it's like, hey, does anyone have this form? Has anyone done this? Can you share it with me? It's much more cooperative in the real world, and I wish law school would change. We'd probably have more lawyers, too, that would help. But good point. You're not an entitled attorney. I think Carmen had a question.
Yeah, I don't know. You said something about when there's a bench trial on the small claims and the judge makes a decision, so when we go to small claims trials, that can be appealed to civil.
Yes, they can appeal it up. I believe if it's beyond that 750 threshold.
Okay, even though it's not reported, the cases or the trials are not reported, it can still be appealed to the civil court?
That's my understanding. Okay. Yeah. You can have a trial. It's trial de novo is what would it be called.
Above 750, right?
Yeah, they're not going to listen to it below 750.
And the process for that would be that they would just have to file a civil case, a civil complaint.
File a motion for a trial de novo. That starts it, and then I don't know if they incorporate the small claims complaint into the new civil case, or they have to replete it. I haven't seen that. I had an interesting one. Someone went through small claims and said he lost. He says, I'll pay it. It was to his ex-wife. He says, I'll pay it, but she doesn't want to take it because she's not happy with what the judge awarded. I don't know what you do then, because there's interest accruing. So I said, here's a motion. I helped him file a motion. file a motion, talk to the judge, just say, can I pay it to the court? Will the court take it? So interest stops, and she can decide what she wants to do. So the judge went for it. I think the money's sitting here somewhere. But the judge told her, if you didn't like my result, you could appeal it. You know, so interesting. It's not the end if you're in small claims. Yes, Hannah.
And I just wanted to clarify, because this is something that we see all the time, is we only have forms for small claims. We do not offer any forms for civil case types. And the small claims forms are available on our website, but there is no forms, even if we're converting from a small claims to a civil case type, there's no forms for what's called a complaint.
Yeah. And Oregon is different. You have to really come up with your own complaints. Other states like California, it's just a form. You check boxes. It's easy to file. Oregon, we'll go over this. You have to state facts. I mean, so yeah, I don't want to say that the Resource Center can do everything for you. It's great what they can do, but it's really trying to just facilitate you filing your own case. Anything more about... You have a small claims packet, right? Hopefully you're all kind of familiar with this. It really is nice. We're going to walk through this a little bit. I might not refer so much to the packet itself, but I took I looked at the packet, made this PowerPoint to say, okay, who do I sue? When do I sue? Where do I sue? What do I state? So a lot of these instructions, I'm kind of taking from the civil case side point of view. So if you have things that you know on the small claim side that might be different, just speak up and say, no, that's a little different in the small claims. But I think procedurally it's pretty similar. So here there's some resources. I think you're all aware of these that people can go to. So you have the Oregon Rules of Civil Procedure. This is kind of tells what are the rules here when we're going to court. So we call them ORCPs. So everybody has access to this. So, I mean, you could read through. It's really boring to read through them all. But I often, when I'm drafting things, I always have to go back to the rules. I don't have them all memorized, or I think I do, and it's a little wrong. So whenever I'm drafting something, I copy the language from the rule, put it in my pleading, or if I'm doing a motion or a response to something. It's just knowing these rules is very helpful, and going back to them, even if you think you know it, it's very important. So we'll go over these ORCPs. Now if I can get out of that, get a question. Back to my PowerPoint. So we'll go over those. You have the Uniform Trial Court Rules. So this is even more detail, I say, at the trial level. It's very, very well spelled out what's going to happen. So there's standards for pleadings and documents. This you'll direct people to in Chapter 2 if they want to know how to format their complaints. What does the caption look like? Where do I have to put signatures? How do I do spacing? It's all in the UTCR in Chapter 2. And usually, though, you can just go on and find someone else's and copy it, like we said before. So I'd say for civil case, so small claims is spelled out in Chapter 15, the procedures, those rules, and civil cases in Chapter 5. I wasn't planning on pulling those up and going through them unless any of you want to have specific questions. The supplemental local rules. So each circuit court is going to come up with their own local rules. We do things maybe a little different in Jackson County than they do up in Multnomah. So you kind of get the judges and lawyers together, usually on a committee. They're going to talk about the rules and how we're going to run things, as long as it doesn't directly conflict with what the statewide wants done. But usually you can come to consensus on things, and that's important. So it's nice. It's important to look at the local rules. I do that if I'm going to go to another jurisdiction. I want to know how do they want things handled. With COVID, it got really crazy. Everybody had all these crazy rules and trying to adopt these local rules, and it's going to the Supreme Court now on changes of statutes of limitation on that time period. Messy time. I'm glad we're past that. Then I think I don't know what you can do in the Resource Center or as court personnel, But if you can point people to the Uniform Civil Jury Instructions, the UCJI, can you?
There's a book on the shelf right
There's a
there.
book right there. This is the place to go to if you want to say, what is the law? This is to go where lawyers and have consolidated statutes and case law to say, what is the law? This is what's read if we go into a jury trial. The judge, both sides pick. Here are all the instructions we want read to the jury so they understand the law. And it boils down the law to real simple, understandable statements. So this is where I would spend time with people and say, go to the UCJI. Do you have a case? Go to this and see, does your case satisfy what the law says? And it takes some time to get through it, but that's, I think, the golden place to go for people. And it's not just my opinion. This is a consensus of lots of lawyers. So these are great resources. Any others? Maybe there's others like iForm on the OJD website for small claims, but I don't know. These are the main places I go. Now, as a lawyer, I can go to bar books. I don't know. Do you have bar books here?
We do have a resource in the law library for bar books. They can
Okay.
come see me, Melanie, to
So you can see Melanie.
get a token.
Bar books is really the place that I go first. You have to get a token. So it's really nice because that really shows how the law is developed. The UCJI is just kind of this plain language thing, but if you're going to argue with the other side, you really need to brief something, you go to bar books. And then if you're ever using cases, you have Westlaw and Lexis both. Very important to see, is my case I'm citing still relevant? Is it still current? Maybe it's been overturned. And some of those are hard to understand sometimes as you read through cases. But bar books kind of is the bridge, so you don't have to go straight to a case and understand, well, what is this saying? Probably, again, with artificial intelligence, I'm reading, it's a big part of practice now, we're using it, but you have to check what you're getting, what you're putting out. The first case I heard about was a New York lawyer that got disciplined because he ran a case through ChatGPT. It was an airline kind of case, airline safety. He just ran it through ChatGPT and submitted the results in his brief. The firm he was going against checked his sources, and they weren't real. They weren't even real cases. And okay, so let's go to the questions. First, usually, is who do I sue? You probably get that a lot. So you have to correctly identify the individual or business. So from your packet in small claims, it's you have John Smith and Angela Smith. You want to get their correct spelling. Sometimes you can correct for a misnomer is the legal term for a wrong spelling on a name, as long as that person should have known it was him or her when they get served. So maybe just misspelled, that's going to be okay usually. But if you have the wrong name, you sue the wrong person. So you might, again, in small claims, have John Smith doing business as X, right? Whatever their company is. And that's okay in small claims. You can also do it in civil. But if they're going to be, you want to just check and see if they're an incorporated or an LLC. And you usually want to do that at this website. I think the website in the packet is filinginoregon.org. This is a little more direct. It goes to this find a business. So if I want to look up, I don't know, what's a business around here? So I'm going to look up, and okay, so here's all the, right? You still have to do some investigation. Everybody that you sue is going to have a registered agent. That's the person you're going to serve papers on. But lots of times you have to get the right business, because again, if you're suing the wrong person, you're not bringing the right person in court, and the court's not going to have jurisdiction over them. So those businesses can be tricky. Then you have some special situations. Let me go back to the PowerPoint. Guardians for so minors can't sue on their own. They need a guardian ad litem. That would be for that item, or you can do a full guardianship. Incapacitated people can't sue on their own. You're going to have to get a guardian appointed. So there's, you're usually going to need a lawyer to do those kind of things. I wouldn't advise people to do it on their own. Because once you set it up, then there's reporting requirements later. And so if somebody's dead, a dead person can't sue. You can't sue a dead person either. You have to set up an estate. So that's in the probate department. They're going to have their own forms and own rules on how to do that. So it's always always have to do a search. Is this person even alive, right, that I'm going to sue? Lots of times you might be able to sue someone acting as an agent for a business. So usually if I'm not sure, is this person acting on their own or are they acting on behalf of the business, I'm going to sue both, right? In law school they teach you sue everyone you can and then you figure it out later, right? You have to have a basis, right? You can't just be willy-nilly. But if you think that person might be involved, you're better off including them. You're safer, and then you can dismiss them later if you realize they're really not acting in that capacity. Lots of times it's called vicarious liability or respondeat superior. So if it's in the scope of the job, usually you're going to get the employer on the hook too. So there's kind of that angle. I don't know if you see that a lot in small claims, but maybe sometimes it seems like people are acting as agents. You're not sure, are they doing this on behalf of a business? Landlords often. Yes. Yeah, you're right. And telling them registered agents, that's not who you're suing.
They would go down in that bottom right corner of the packet.
They would be who you're serving the summons to.
Right.
Yeah, but you're not suing that registered agent. Really, they're usually lawyers or accountants or business places.
Okay.
So again, it depends on how much interaction you've had before. Lots of times, if you've already made a claim against that person, and it's against an LLC, and they've had like a lawyer respond or something, you're probably okay going against the LLC because they're probably acting within the scope of their business. But sometimes people mix up their business and their personal funds. They mix up their business and their personal life. So you can sue both. You might want to say, I'm going to sue both just in case the insurance company behind the business is not going to cover this incident, right? Because they went outside the scope of their coverage. One that comes to mind was, so I represent a young man that died in a house fire. So we sued the landlord. It was a crazy house, like 20 people living there, all these crazy safety violations and stuff. We sued the landlord under their personal name and their LLC. So I sued the landlord individually and their business name. So once I sued them, the landlord, their insurance company said, we're not going to cover this loss. Because when the landlord put in their application, they said the unit was 4 units, and it was actually in the zone application had 5. So they're saying they were dishonest in their insurance application. We would not have insured this unit because it was 5 units, not 4, because they had only paid for the 1 to 4 coverage. So now I'm in a coverage fight, right? Now they've sued the owners are now in a fight with their insurance company, and I'm in there because my client was the one killed because they didn't have any fire alarms, and it was electrical fire that caused the fire in the house. So my young guy died. So now we're in this fight. So that's where I'd say sue both, because you don't know if that business is going to get covered by their own insurance. Now maybe the people have their own money, but to pay for this kind of a loss of a life of a young man, probably not. So I really want that insurance coverage in play.
Yeah.
Most businesses are going to have insurance for their errors, their omissions, their liability, right? So again, I'd go look at that, find a business, see who the manager is of the LLC. You're going to see who owns it, if it's a single member or multiple people. You're going to kind of know who's in play. Hopefully you've done some correspondence before and you know who you're supposed to sue. If you're in a contract situation, look at that contract. The contract is the entity. That person that wrote the business is the one that you're going to be suing. And they should have a clause in there. Who does service go to? Are they going to go to arbitration? Are they going to go to which law is going to apply? Is it Oregon? Is it some other state? Right? So you have to look at who's supposed to get notice, how early of a breach of a contract. Maybe you can't sue right away. You got to give some notice, so to try to remedy the breach. So those are kind of questions on who to sue. Any other questions on that? Again, I know you're not supposed to give advice on it, but these are things that you're inevitably going to get. Where do I sue? So in ORCP 4, it's all about jurisdiction. So you need subject matter jurisdiction. Usually most claims are under state courts. Sometimes you have federal questions, right? Federal, or you have diversity of parties. So, you got a corporation in another state that sold something on Amazon to someone here, and it blew up on them when they open it up. Maybe you're gonna end up in a federal case, right? Because you have diversity of parties. One's here, one's in another state. They don't really have ties to Oregon besides selling it on Amazon. So you might not have subject matter jurisdiction here, or it might be airplane law or admiralty law if it's on the water, even lakes. I mean, sometimes there's federal questions, IRS. You're not going to sue the IRS in this court probably. So there's different subject matters that state court's not going to have jurisdiction or power over. Now, if you're going to sue them in Oregon court, you also need personal jurisdiction. So is the person domiciled here? Do they live here? Is the business engaged in activities in Oregon? If they're registered in Oregon, you're good, right? Or is it in local act? So I might have a Washington resident and a California resident crashing on an Oregon freeway. I'm going to file in Oregon because that's where it happened, even though someone's in Washington, someone's in California, right? So where did it happen? That's going to get you personal jurisdiction. The court has some power over these people. When you hear about venue is just which county in Oregon are you filing. You can actually file wherever. I always try to file in Multnomah County because Multnomah County juries are more generous than Jackson County juries. Everybody knows that. It's not a secret, right? We don't make a lot of money in Jackson County. And we're just not as free, with money as Portland attorneys or Portland juries might be. So I'm always going to sue in Multnomah County if I can. But lots of times they're going to say, it's not the right venue, right? It happened down in Jackson County, so everybody involved is in Jackson County. And it's really about the convenience of the parties, the witnesses, if the doctor's going to be down here. So the defense side wants to move it to Jackson County because they know the jury's not going to award as much. So there's sometimes a fight about venue in the beginning. You probably don't get into that too much. But if it happened in Jackson County, or the defendant lives in Jackson County, or the defendant does business in Jackson County, you're safe filing in Jackson County. It might not be the wisest thing, but you're safe doing it. Any questions about where to sue? How do I sue? So here's ORCP 7. Talks about filing complaints and issuing summons. This is a long section in the ORCP, very detailed on. Because for fairness, we have to give people notice that they're getting sued and what are they getting sued over. So the case isn't really started. Most cases aren't until you've actually served it. Filing it is one thing, but you actually have to give that person notice. So some people think, I filed it, I'm done, case started. Not really. You got to get that person notice. So there's a proper form, and I believe you have it in the packet, and it's set by rule of what they're being sued. They need to go to court. They should get a lawyer, and they have usually it's 30 days in which to respond.
So civil complaints, right?
Yes. Small claims is small. What's small claims? 14 days. Mm-hmm. Yeah. So civil usually get that 30 days. So you have to have the right notice, especially like landlord-tenant. If you have the wrong notice, you might be exposed to legal fees on the other side. So you got to get that notice dialed down. Now, the manner of service. Lots of times people think, I sued. I can maybe in small claims, can you just go serve your own?
You can mail it yourself. But
you can mail it yourself. Okay. And you always want proof of what you're doing. In civil case, I usually need to use a non-party. I need to use someone else that's going to go serve that. And they're going to swear in an affidavit that they found so-and-so. He's 5'6", 200 pounds, brown hair, brown eyes, served in the papers at this location on this date at this time. right? So that's personal service, if you can get them directly, right? A lot of people use the sheriff to do it, or there's private process servers. You don't even have to. You can use anybody as long as they're an adult, sound mind, but it's usually better to use a professional, right? Because you don't know, nobody likes getting sued, and so you don't know what's going to happen once you get served those papers. There's substitute service. So substitute is if that person's not there, but they live there or they work there, you can serve the papers on someone there, but you have to follow it up with a mailing, right? So you have to be sure maybe that person didn't pass, they hit it, didn't tell the person, they're going to say, I never knew. Well, I also mailed it. That's good enough for the law. If you substitute service, you have that affidavit, and then you have an affidavit of mailing, which you usually do in small claims. You can serve at the person's office and mail. You can also, if you want alternative service, you can get a court order. So usually a judge is going to say, have you tried? Try a few times to do it personally, but we can do a publication. Well, I don't even know who looks at the paper anymore. Nobody, but you have to pay, right? So you can do posting out in the lobby, right? You can post it. I don't know who comes to the court usually. Not many people come look.
I'll tell you my favorite, Justin.
You got one, right?
Is what I'll do is if I need to do alternate service, I'll take the papers I want to serve, I'll put it in the cloud, I'll create a link, and then I'll text that link to the person's cell phone. I get the court to approve serving by downloadable link to a cell phone. And you say, you've been served to see your papers, hit this link, and then you got it.
Great.
Yeah.
Our alternative form of service packet does include electronic services like email, social media, fax,
Yes.
Yeah.
and texting.
Yeah. So that's it. But you need a court, you need permission. You can't just think,
Yeah.
we were talking on Facebook, and now, of course, it's going to work. Well, no. You got to get this judge to say, yes, I see you guys were talking on Facebook. This should work. Because, again, it's about fairness to that person. Because if they don't answer, the judge is going to try to order, you're going to ask for a default, and then you're going to get a judgment, and you get a lien on their house. It's like, well, I never even knew about this thing, right? So there has to be proper service, proper due process, right? That's what's in the Constitution. So if you're suing a business, you can serve on that registered agent. You need that proof of service of the summons and the complaint by a non-party in civil cases. You can do mailing in small claims. Anything else about how to sue? This is kind of high-level stuff. Yeah.
The service for the businesses, we get a lot of people asking if they can't, like the business went out of business or they can't find the business. How are they going to sue or how are they going to serve that business?
I've always been able to find the original owner.
We've had a couple where they weren't.
But and they'll say, I'm out of business, I don't have any money, go ahead and sue my business, get a default, I don't have anything under that business. When do I sue? Statute of limitations are huge, right? Oregon Revised Statute or ORS 12. So I put in most of the ones that we deal with in the civil world, and I don't know if this goes beyond what you can do in the resource center and telling people their rights or not, but there's tort claims. Again, a tort is an injury. If you're going to make a claim against a public body, like I tripped in a pothole, right, and broke my leg, that's a public body usually controlling that street. You have to send them a formal notice within 180 days. They have to know that you're going to make a claim so that they can investigate it, right? Even though the injury claim is 2 years, you don't have to resolve the claim until 2 years later. You have to give them notice within 180 days. I don't think it sounds fair, but government writes the rules, right? So they have a little more. Here are the other ones. Personal injury claims, 2 years. Wrongful death versus public body, 2 years. So again, the government gets a little shorter. Wrongful death versus a private entity, you get 3 years from the date of the death, so you get a little extra time. Contracts on real property, I've never done one, but I understand it's 5 years. Contracts claims generally, you have 6 years. Again, this is to file the claim. File and serve, right? Adverse possession, sometimes you might hear this. This is, someone's been using my land, it's a neighbor, they've been using my land for forever, and now, I can't get into my property, I can't access it. If they've been using it for 10 years or more, you might not be able to take that back because they've adversely possessed it. If you have a judgment against someone, you have to act on it, you have to collect on it within 10 years. or renew it, you can get another 10 years, but then you're done. After 20 years, you can't renew that. Ultimate repose sometimes is a catch-all. Like, I don't know, it doesn't fall under any of these. You have 10 years. That's what the legislature said. There's tolling. You might hear the word tolling. That means just kind of pausing the statute of limitations on a case. Again, you have a discovery rule. This happens a lot in medical malpractice. Well, I was supposed to recover and my doctor kept saying, oh, you're fine. It's just going to take 6 months. It'll take fine. And then after 6 months, you realize, no, this pain's not going away. They get an MRI done or an x-ray. Oh, you had something in there. They left us, I've had someone leave a sponge or leave some other tool. Okay, now, it didn't start back then, but now it's starting because now I realize the recovery period's gone. And now the 2 years is going to start from that date that I reasonably should have discovered. It's kind of squishy, right? If you're a minor or you're disabled, let's say you're unconscious, the time's not going to start until you're out of your minor period, so you turn 18, then it's going to start. Or you come out of you're back in your right mind and you can deal with things. If this probably comes up quite a bit, if the statute of limitations ends on a weekend, you actually get till the next judicial day. So, if it's October 1st, but Saturday, does that mean I can't file? Well, you can file, especially with e-filing now, you can file. But even when the court's closed, they won't accept it till it's open. And you're kind of never wait till the last minute like this, but sometimes it happens. But usually if it's going to happen on a holiday or closed day, weekday, you get till the next day that the court's open. Okay, what do I state my case? This is going to be very case specific. But if you're making a claim, you're the plaintiff, look at ORCP 18, you have to have a plain and concise statement of ultimate facts. You have to have a demand for relief, an amount of damages. Like I said, you have to say what is it that you want. There has to be an amount. Okay, and it has to be clear enough the person can defend. Like, what are you saying I did wrong? I got to know. Now, when you file a response, this is the defendant under ORCP 19, it's usually their answer. They have to admit what you allege, deny it, or say I don't have sufficient knowledge, which is really a denial, right? But they have to say what their affirmative defenses are. Like, well, it was your fault. You weren't watching where you were going, right? There's different affirmative defenses you can include. Now, often a defense will file a motion to dismiss. It's called under ORCP 21. That's if you don't have jurisdiction over the person. Like, I've never been to Oregon, and my business doesn't do anything there. I wasn't served. I found out it some other way, but I wasn't served. It's beyond the statute of limitations. So they want to bring up those before they even get into the case to try to get rid of it, right, from the beginning. That motion is dismissed. If you don't bring those up in the beginning, you're going to waive them, right? You have to bring those up in the beginning. You can't bring it up later. You can always amend. You can amend claims and responses later. So how do I proceed with my case? This, as litigants, you have a pretty good page here on, what's court going to be like. But this is all before you get to court. So you're entitled to discovery of documents and persons under 36, perpetuation of testimony. You can get people that are witnesses or parties to the case. You have a right to question them under oath. If there's medical issues, you can do a physical or mental examination of the person on the other side, and that can be court ordered. You can agree to the parameters of it. But like, I want my doctor to review that person. My doctor's going to testify and say that person's not as hurt as they think. Okay, they have a right to that. A request for admissions, you probably don't deal with that, but that's where you want to narrow the issues going to court. Will you admit that this accident happened? Will you admit that you were negligent? Will you admit that the medical bill is reasonable? Right? You can get them to admit to things and not have to fight it in court. You have subpoena power. Once you have a case open, there's a lot of power. You can get the court to issue subpoenas on your behalf, to get records, to get people to testify. Now, once you've gone through these, if you see, well, there's really no case here. I think it's so one-sided the judge can just decide on the law. There's no question of fact really here. It's a question of the law. You can file for summary judgment, and the judge can hear it and make a decision. But usually, if there's any question of fact, it's going to go to a jury. But if it's just a legal question, judge could probably decide that and
But just, you gotta tell them, on a big money case, every case is gonna get a motion for summary judgment.
Usually. It's because the defense attorneys, they get paid by the hour. I don't.
Yeah.
Defense attorneys get paid by the hour. They're going to file motions as much as they can, right? So keep it going, get their bills going. So, but yeah, summary judgments, and you want to be sure, especially if it's a kind of a murky area of law. I don't know, what's a judge? And judges are always going to look for precedent. They don't want to be the first one to decide this. Well, what did some other judge decide? What did the Supreme Court decide? First, they look at statutes, they look at rules, they look at other cases, right? And that's what you brief with the judge. You're entitled, again, in a civil trial, you are entitled to a jury. If you want, you can do 12-person or 6-person. You have to have 9 of the 12, 5 of the 6 agree on your verdict. But you are entitled to trial. But the state's not going to pay for it. If you have to pay your own, right? Judgments. If you get a judgment, you could get a default judgment. You still have to explain to the judge your case. It's called a prima facie case. You still have to have enough evidence, but if the person just doesn't show up, you can get a default judgment. But they can always set it. They can move to set it aside later. Oh, I got a lawyer. I didn't understand. Judges are usually like, okay, let's go ahead and do it again. So that sometimes you might see that coming through. Then enforcement and satisfaction of judgments. You usually need a lawyer. You can garnish wages, bank accounts. It can't be like disability payments and stuff like that. So you have to be sure you're getting the money from the people.
We do have a couple books in the library here that talk about collection after judgments.
Yeah. And those forms, you could probably get those forms. Here are the forms.
Online.
Figure out how to do it. It's not easy. How do I prove my case? I think you wanted to talk about evidence. We're almost out of time. But the burden of proof. If I'm the plaintiff, I'm bringing the case, I have the burden of proof. I have to prove my case. In civil, we don't have to do it beyond a reasonable doubt. But we do have to do a preponderance of the evidence, which is more likely than not. If you put a percentage, I'd say 51%. If you have a coin flip, you got to get on your side, at least 51%, right? That's how the judge is seeing if evidence can get in or not, and what you have to prove. Now, the Oregon Evidence Code is under ORS 40. This is what we fight a lot about if you're in trials, or even before, what is going to be admissible and what's not in testimony and records. There's some presumptions, very simple things like we shouldn't have to go back and say, if I send a bill or I accept it, I paid you and the check was deposited, it means you got the money, right? It doesn't mean somebody else took it. There's some presumptions. Is it relevant? Is it going to help decide the case, right? Does it help decide the case? That's going to be relevance. But if it's relevant, but it might be excluded for prejudice. So lots of times, it might be so bad and it's really not that relevant, and how bad it looks on the person outweighs the relevance, the judge is not going to allow it. So if I don't know, there's lots of these kind of things. But lots of times past criminal histories, maybe they have some issues with substance abuse or something, but in this case there wasn't any, right? It's not relevant. Maybe it's a little relevant, but it's too prejudicial. I'm going to throw that out. Their character, you can get in 404 if they have a pattern of things. Subsequent remedial measures, this comes up a lot, 407 in my premises cases. So if I trip and fall and they fix it later, let's say they don't think there's a problem, but they fix it later, we can't bring in the fact that they fixed it to say that there's something wrong. Does that make sense? Kind of seems weird. It's like, well, shouldn't you be able to use it against them? It's like, no, we want people to actually fix things. Because if I sue them over it, they're not going to fix it. They're going to say, no, there's nothing wrong, because I don't want to prove that, this is just going to hurt me. We want things to fix, people to fix things and not be held against them. So that's what the legislature said.
Same way settlement negotiations. You can't bring in settlement negotiations because people have to be able to talk to try to resolve it.
Yeah. You can't talk about insurance, usually in court. They'll say, don't worry about insurance, just award what's fair. Don't worry about what they can pay. Again, I don't like that one, but that's in the rules. Privileges. People have privileges. If they're talking to their attorney, that can be protected. They don't have to disclose that. A medical professional or their spouse. There's other privileges, but those are the main ones. You can use some things to impeach witnesses. If you want to prove that they're lying, change their story. There's some things you can use that otherwise you wouldn't, that would be inadmissible, but you can use it to impeach them. If you're going to have you always need expert testimony if it's going to have to do something that a lay person can't. Like, even if a a car came in here and, ran over Carmen, and she broke her neck, I still have to have a doctor come in and say, yes, that car could have it did break her neck beyond a reasonable degree of medical probability. You have to pay an expert to come in and say it, even if it seems obvious. Like product liability, a lot of things you're going to need experts, and they're expensive. So I usually tell people, if you're going to go to trial, it's $10,000. Pay these guys to come to trial. Hearsay, you always hear about that. It's usually inadmissible if it's someone that's an out of court declarant. If they're not there and you can't question them, you can't use what they said to prove the truth of what you're trying to get in that they said. There's some exceptions for those. There's lots of them. We don't have time to go into them, but lots of times for standard records, business records and things, usually you can get those authenticated before, and you can admit what's said in there as a hearsay statement. Tort claim versus contract claim. We talked about this a little bit. I don't know if you get these questions, but again, you can point them to the Uniform Civil Jury Instructions, and it explains these well. But here's the elements of a tort claim. You have to have a duty of care that's owed by the defendant, right? So lots of these are set by law. Like if we're driving around, there's laws. They establish what's the duty of care. If you go to a doctor, there's a reasonable standard of care that they're supposed to undergo, right? So there's a duty. It can't just be random. Like I had an interesting one. Someone went to a business and was going to go up the business. I can't remember what it was, but he was changing something on a ladder, changing a light bulb, and a guy just came up to hold the ladder for him, and then he fell and broke his leg. And he wanted to sue the person holding the ladder. It's like, I don't know, is that a duty? Did they undertake a duty there? That one I still didn't answer. But they don't really have a duty. They're not the business owner. They just came and helped. Usually there's a Good Samaritan law that shields you from that duty. But you have to establish as their duty. If you're going into a business, they have a duty to keep it reasonably safe for their customers. You're an invitee, right? If you're a trespasser, not the same duty, right? You can't have booby traps for trespassers. But it's not the same reasonable, like if you're an invitee for a business. Breach of duty, you have to establish what did they do wrong, how were they negligent. You have to prove it was a cause to the injury to the plaintiff. That's where lots of times you need expert opinion, especially when it's like, they're really hurt and there's not a lot of damage to the car, happens all the time, and they're hurting years later. I got to prove that this caused that injury. And then you have to say, what were the damages? Medical bills, lost wages, pain and suffering, damage to my car. Now, the elements of a contract claim, I don't profess to be again, like I said in the beginning, I'm not an expert. I'm an expert in injuries, not in contracts. So I would send them to a contract friend. But here's from law school what I remember. Form 8, you have to prove that a contract was formed. So there has to be an offer, it has to be accepted, there has to be some consideration, some exchange of value. It can even be $1, right? It has to be something. That's why you always see it for $1. It's like, that's stupid. Why? It has to be some consideration. Otherwise, it's just a gift, and there's no responsibility, no obligations. So if you give $1, there's some responsibilities. If I'm the plaintiff and I'm going to sue the defendant, I have to prove that I performed my part. So there has to be some performance. Then I have to prove, what did the defendant do wrong? They breached it, right? They didn't pay me. They didn't do the work, something. And then what are my damages? You can't get pain and suffering under contract, right? Well, it caused me all this stress. I understand. But it's about money in the contract, right? But what if, I had to pay someone else to come and do it for me, right? That person, and I lost out on the money I already paid them. So those are your damages under the contract, right? Now, you want to look at the contract. There might be some actual spelling out of what damages are in there, right? And again, that contract is going to control how, usually if it's a well-written contract, it's going to say when things go bad, here's how we deal with it. Now, here's something, I don't know, maybe you can tell people this or not in the Resource Center, but this is what I usually tell people. If it's a claim that comes to me and I just feel like, you know what, I'm too busy, this is too small. But here's what you can do on your own. The Oregon legislature realized that some claims were so small, no attorney would take them. And insurance, especially in injury cases, insurance companies were lowballing people, knowing no lawyer's going to take this. So they made this law. They said, if you have a claim that's $10,000 or less, right? and you make a demand on the person. It's either 20080 is a tort one or 20082 is under contracts. And again, if there's no attorney's fees in the contract, there's no attorney's fees under torts. You know, I didn't make a contract. I wasn't planning on hitting you. But under contracts sometimes. But if the contract doesn't have it, you can do this. So you can say, I'm going to make a demand on you. I'm going to send you a packet. Here's my not, you don't have to drop a complaint. It's just a letter. Here's the proof of my damages. You know, I had $5,000 in medical bills, and I want $5,000 in pain and suffering. And pay me this within 30 days. If they don't pay you that amount that you wanted, and you go to court, even small claims, and you win, well, I guess in small claims you wouldn't have attorneys. If you go to civil and you win, you can get attorney's fees on top of whatever, and you beat the offer that they made. So they said, no, or I'll give you $500. They no, you go to court and you win $7,000. So you beat their offer, you can get the attorney's fees on top of it, plus you get your costs, plus you get what's awarded. So this little $10,000 case, if you get an attorney on it, attorneys can always blow everything up, right? Now it's a $50,000 case, and they could have sold it for $10,000. So that's getting people to the table, I think, a little bit, and saying, okay, you could solve it, you can resolve this for $10,000 now, even if you don't think you're at fault. But if you don't, we'll sue, we'll go to trial, we'll win, then we're going to get hit with $50,000, $100,000 in attorney's fees for going through for a trial. Does that make sense? No. Let's compromise, pay the $7,000 or whatever, right? So that's a little thing that's good in Oregon, not in other states that I've seen, where it helps pro se people get bigger companies, insurance companies, businesses to the table a little bit. Okay, any questions on torts versus contracts? No. Those are the main ones that I think you see. So I brought some sample complaints. So I gave you some sample tort complaints. One for dog bite, one for medical malpractice, one for a motor vehicle accident, one for premises liability, which is a trip and fall or slip and fall. This is what most complaints look like. You know, you file this pleading paper, and it's really, I don't know how long we're going to stick with this. Maybe we change, because most people don't like word processing. But for now, this is what it looks like. Why do we have these numbers on the side? Then you can go back and reference. You can find it easier. You can say on page 1, paragraph 2, line 18, it says this. That's why we have these numbers, right? But usually you want things broken out into paragraphs so you understand what's going on. But here, so what I'm alleging is I'm trying to get jurisdiction down, saying this happened in Josephine County. This is just, what's the duty? She has a duty. The defendant has a duty to exercise reasonable care in the control of his. Now she got hit by a bicycle, which was interesting. So I pulled this one up because I won, which was interesting, because usually people don't get hurt by a bicycle, but this one did. So what did he do wrong? He wasn't keeping control of his bicycle. He failed to yield to her. So I sued for her medical expenses were crazy. It was like $15,000 and $50,000 in pain and suffering. So interesting case. So there's all the elements that we were talking about in the tort, right? Duty, breach, causation. Well, the injuries were in there. Was it a neck and shoulder? You don't have to be super specific, but enough that they're going to know, okay, what am I defending here? So what are my damages? What do I want? We call it a prayer, right? Prayer amount. You know, we're not asking God for this, but it's an old way to do it. So that's what that looks like. This is public, so you can give it to people. The next one. Now as you can see, I wasn't sure which one to sue. Right? Then got the wrong one out. This is, I think, a slip and fall on the premises. Number 3 has that extra, reasonable care. So they need to inspect. They need to keep places reasonably safe. They need to inspect for hazards. But there's no bright line rule. Like, you have to look for every 30 seconds. It depends on the business, or 30 minutes. It depends on the business and traffic. And so it's really kind of squishy. So that's usually a question of fact. What should they have done differently? They should have kept it dry. They should have put up signs. They didn't watch for the condition of the surfaces. So there she hurt her head, neck, back, hip, leg. It's okay if you have prior injuries. You can say it's an aggravation of a prior one. So they're, 14,000 in medical, 80,000 in pain and suffering. There's no formula on what you want for pain and suffering. You're supposed to do whatever's reasonable. That's how much you want it. So I usually will go 10 times. Just, there's no, but most cases, juries here are going to be, there's a range, but it's usually 1 to 2, maybe half, sometimes none. It's really, that's why it's kind of a gamble to go to trial. You don't know what a jury's going to give. The next complaint is for a dog bite and the pit bull. So here I sued all defendants. Is the owner of the dog, but she's renting the house from the house. So I sued them all, right? So this is an interesting one. I got the judgment against the dog owner because she has to control her dog. This was a teacher, COVID times, delivering an award for a student and got attacked by the pit bull. So, he got bit, didn't want that. So I sued both. I lost against the homeowners because you have to prove that the homeowners knew or should have known the dog was dangerous. They, we went to arbitration. In arbitration, they say, we had no idea. They weren't supposed to have dogs, and there was no signs of them whenever we went by. And so, no way I could really prove that they knew or should have known. Didn't have any other prior incidents. So Oregon kind of has this one bite rule with dogs. The first time your dog bites someone, you kind of get off on pain and suffering. You still have to pay for medical bills. But if your dog does it a second time, now it's on you. You have to pay pain and suffering. Other states don't have that. We love our dogs. Then the last one, this one I threw in because it's what everybody's talking about when everyone sees me, is the big case against. This one's still going. I filed this lawsuit in January. There's lots of those still coming. It's an interesting one. So in here, medical malpractice is a little higher pleading. Again, you have to have plain, concise statement of ultimate facts. That's hard in medical terms. So really, anytime you have a medical malpractice, I always run it. I have a doctor review it. Doctor gives me, what did this person do wrong? What did they do wrong? And then I'm using that expert opinion because I'm not a doctor. So I'm putting in what happened to my client. And so I give a pretty detailed explanation of what happened, and then what did they do wrong, what did they do wrong. And then what are the damages? Unfortunately, he died. He contracted a bacterial infection and ended up dying. So I have a wrongful death claim against them. And notice I sued in the name of the estate, right? He's not alive. Can't sue for him. It's his estate. He has a personal representative appointed who was his wife. So
did you bring that in Jackson County? Because if you brought it in Multnomah County, because we're being kicked out.
I don't really have ties. Yeah. There's no real ties. They don't have a hospital up there. Yeah. So yeah, it's here. But those are hopefully, kind of helpful. But again, you're looking for these kind of things. Figuring out, you got to put in elements of things. And you can get those from the UCJI. And usually a judge, that's going to pass and enough to get the case going and get to the judge.
Yeah, and what we get to do is we just bring people into the library and we show them the books. We can also show them the OJD terminals where they can look up civil cases. So I can pull up a case and they can do their own look at on the public stuff.
Yeah.
And
Yep. Then they can see, because this is just the beginning. Then there's lots of other filings later. You can see
what comes next.
See how all this other stuff goes, right? Yep. All these other steps.
And then I